Okay, well, we're letting everybody hop in, and as we do it, just as the other webinars we've done, we'll have a short statement by one of our great candidates here in Harris County, Sima Ladjevardian, as well as some information on what's going on statewide from Rosemarie Clouston with the Texas Democratic Party. But hang on about another 60 seconds, and we'll get started with our program. And I know that everybody has already had a chance to kind of get a preview, but we're very honored to have the expert on Native American law here today. And I'll give you a heads up. He's also offered to answer any questions you might have about Native American law, whether it's from gaming or whatever else you might have. So he's not limited to this very important Sentinel U.S. Supreme Court case. So just hang on for about another 45 seconds and we'll get started with our program. Thanks again for joining us today. Okay, great. Nice crowd today, and it looks like there's some more going in. I'll go ahead and get started, so we'll stay on schedule, which is something we always try to do. We've also had the opportunity to invite members of the State Bar of Texas's Native American Law section, as well as HBA Appellate section. And if you're here for the first time, thanks for joining us. During the extent of the pandemic, for as long as it lasts, Harris County Democratic Lawyers has made a commitment to offer their programming free to really anybody, not just lawyers. And given the topics, we've had great attendance from across the gamut. And you're welcome to share this information in our schedule with anybody that might be of interest. I'll give you a preview on Monday. James Carville, we're co-sponsoring with the Meyerland Democrats, Art Pronin, will be doing a dialogue with our members. If you check our website or Facebook, you can have the login or registration information for that as well. And then on September 3rd, James Dean, who's the former counsel in the Nixon White House, who's been working hard to deal with the last time we had a president run amok, will be joining us for a question and answer. He's written a new book talking about some of the same issues that are parallel between what he was seeing, what he was inside the White House in 1974, and what we're seeing now in the last 100 days, hopefully, of the Trump White House. At this point, I'd like to turn it over to Rose Clouston from the Texas Democratic Party to give you a little bit of update on some of the things going on statewide.
Thank you so much, Mike, and thank you to the Harris County Democratic Lawyers Association, who are always so generous and such amazing hosts and have such incredible topics. I'm really looking forward to today, but wanted to give a quick overview of some opportunities for y'all with the Texas Democratic Party to help our slate of amazing candidates up and down the ballot. We got some great news yesterday that we are going to have an incredible vice president in Senator Kamala Harris in just, well, I guess the election is in 83 days, and that's the number I'm laser focused on. I don't know how many days until inauguration, but a few more than that. But very excited about all of those things happening. And this past weekend, we contacted over 2 million voters across the state because everyone knows that Texas is the biggest battleground state in the country. And part of that is engaging y'all in the legal community in these efforts and using your particular skill set and problem solving skills to benefit those candidates and the voters, most importantly. So we have launched the Texas Democratic Lawyers Association, which is the official entity by recognized, by the Texas Democratic Party for legal professionals. And this is inspired by the success of HCDLA here. And we have chapters across the state for all of you to get engaged in. So our laser focused for the next 83 days is the election and voter protection, which is my piece of the pie at the TDP, because this is the most important election of our lifetimes. And we have seen article after article and threat after threat from this president and the Republican Party that they are intending to make voting more challenging, which we've seen in this state by being one of the few that is not allowing folks to vote by mail in large scale. And, the president threatening to have poll watchers across the state, across the country that would intimidate voters. So we really need your legal skills on the case. Serving as election workers or answering voters' calls to our hotline. So I'm going to put in the chat, we have a place for you to sign up and would love your support and look forward to working with y'all and seeing you on the future events of like these CLEs and also at polling places on November 3rd. We look forward to having your help. Thanks, Mike.
Thank you, Rose. Now we have a short, as consistent as we've always done it, opportunity to hear from one of our great candidates in Texas, and in particular, Texas's 2nd District, Sima Ladjevardian. Harold, please go ahead and play it. And after 3 minutes, actually less than 3 minutes, we'll be back with our main program.
Hello, everyone. Thank you so much for having me here today at the HCDLA meeting. I wish we could be there in person together. My name is Sima Ladjevardian, and I'm running for Congress in Texas 2 against Dan Crenshaw. I am running to recover the health of our families, the health of our democracy, and the health of our American dream. I never thought I would be running for public office, but public service runs in my family. My grandmother was one of the first women in Congress in Iran and helped pass the women's right to vote at a time where progress seemed impossible. I want to continue in her footsteps. It may look daunting going against Trump's favorite Texan, but I have defied the odds all of my life, as a woman, as an immigrant, as a cancer survivor, and as an attorney. I remember being a child in the streets of Iran during revolution and just really thinking about how we would leave the only home that I knew. I was scared and I thought I would give up, but I defied the odds. I remember all those years later coming to this beautiful country, achieving the American dream, being successful with my husband, with my 2 kids, and hearing the breast cancer news. I remember being scared. I thought I would give up, but I did defy the odds. And what's happening right now reminds me a lot of all those life-altering moments. We're living in a nation where millions are protesting injustice and brutality, where we have a president and a congressman who want submission without any kind of progress. We're living in a nation where hundreds have perished from a virus and millions have lost their jobs. And we have a congressman who wants to take healthcare away from the most vulnerable and just spews out lies about what's going on. We're living in a nation where our back seems like we're against the wall, and that beautiful American dream that I was able to achieve of life, liberty, justice, equality seems at risk. But I've seen it, that together, when we all come together, we can, we will, and we must defy all the odds. As your congresswoman, I will make sure that I fight for high quality healthcare for everyone. I will make sure that we confront our climate crisis before it's too late. I will make sure that every student receives an education that matches their potential and where no parents should fear that for their children's safety after the latest school shooting. And I will make sure that equality and justice are the expectation and not the exception. Beto lost this district just by 3,000 votes. I have been put on the red to blue list by the DCCC, making this one of the most flippable seats in the nation. I know together we can win this. I want to ask you to join this movement. Help me make this American dream an American reality. Please join us on Sima for Texas, SIMAFORTX. Contribute. You can give up to $2,800 per person. Please volunteer and amplify our message. Thank you so much, and wishing you a great day, and hope to see you soon, and let's win this.
So one of the great things about, actually probably one of the very few great things about what we're going through in these current days is the opportunity to really get a view of all these different candidates that we have across the state, and incredibly powerful testimony that every single one of them has. Today we're joined by Professor Lindsay Robertson. Being from Texas, and I know not everybody on this is from Texas, it's kind of not frequent where you point to the state north of us and say they're really ahead of us, but OU Law has the expert on Native American law in Professor Robertson. I'm also proud to say that he's a Wahoo. We actually overlapped when he was getting his history degrees when I was undergraduate there. And what I think you'll find most intriguing, not just how he got into law, but his perspective on what this case means, not just for the particular facts, what it might mean for Tulsa, Eastern Oklahoma, but what it means about the recognition of the importance, not just of Native American law, but another area that I know he's very familiar with, and that is indigenous peoples and the challenges they faced. And in addition to serving as a professor at OU, working with the UN, he's also a justice on the Cheyenne and Arapaho Supreme Court. So we have today joining us someone who has a very wide viewpoint of a lot of issues that are very important to millions of people around the world. And I'll leave WIS and turn it over to Professor Robertson with one kind of heads up. He's volunteered not just to address this important case and what it means on the facts, on the law, what it means for the entirety of recognition of the rights and the past obligations towards indigenous peoples, but also any other Native American Indian law question you might have, from gaming to whatever. So he's going to reserve quite a bit of time for questioning. Thank you, Professor Robertson, for joining us. We look forward to hearing from you.
Thank you, Mike. I'm delighted to be here in very distinguished company. It's a pleasure to have an opportunity to speak to educated audiences anywhere about Native American topics, and my experience is when it's a non-sort of Indian law focused audience, as Mike just mentioned, people come with lots of questions and really no one to ask. And so for this reason, what I proposed to Mike I would do is I'll talk about the McGirt case and its and my sense of its impact, not only within Oklahoma, but sort of outside the bounds of Oklahoma, and maybe what it tells us about this new Supreme Court majority in the Indian law space. But I want to also leave plenty of time for those of you who have questions about how Indigenous peoples law works here or internationally to ask them. And over the years, I've been doing this for 30 years plus. I've had questions from what's the deal with casinos to do Indians pay taxes? And where do these car tags come from? And all of those questions I'm more than happy to field. This is, you know, a protected space, sort of. I guess it's being posted on YouTube, so maybe not so protected, but feel free to ask me anything that you want. And again, I'm more than happy to answer it. So McGirt versus Oklahoma. Some of you will have heard the oral argument. Most all of you presumably have heard of the decision. Some of you may have read it. It's been widely viewed as the most significant Indian law decision of the modern era, certainly of the 21st century, for a whole host of different reasons, and I'll touch on them at the end. But before I do, I want to give you a little bit of historical background so that the issues make sense, the arguments make sense, and the decision makes sense. The Muskogee Creek Nation is the tribe whose lands were impacted by the decision. Their lands historically were in western Georgia and eastern Alabama. In the 1820s, they ceded their Georgia lands, so they became an Alabama tribe. And then in the 1830s, after a series of Supreme Court decisions that we call the Cherokee cases, the Muskogee Creek Nation signed a treaty agreeing to exchange their lands in Alabama for lands in what would become unofficially known as the Indian Territory. And so they moved out here at the same time. 4 other tribes entered into the same sorts of arrangements. Different topic is how fair they were, or whether they were lawful from a tribal perspective or not. But these various tribes, these tribes included the Cherokees, whom you've heard, and the Chickasaws and the Choctaws and the Seminoles, in addition to the Muskogee Creek. And we call those tribes collectively today the 5 nations. They used to be called the 5 civilized tribes because they had converted to agriculture, and several of them had written constitutions and this sort of thing back in the 1810s and 1820s. The migrations of each of these tribes we call collectively the Trails of Tears because they were superintended by the US military. Many of the tribal members attempted to stay. They didn't believe that this was just, and they certainly didn't support relocating to what would become the state of Oklahoma. And so we have 2 consequences of that. One is that there are remnants of many of these tribes still existing in those states. There's an eastern band of Cherokees in western North Carolina. There are Seminoles in Florida, as some of you may know because they have a fairly well-known casino, etc. The other consequence and sort of story that's known is that there was a lot of death on the marches out. Again, people, old people, children walking over enormous distances with essentially no meaningful medical care, and the weather wasn't good for much of the walk. And so these trails of tears migrations are part of the stories of each of these 5 tribes. Muskogee Creek ended up out in Oklahoma in the 1830s. They had a fairly sizable reservation. What became Oklahoma was divided up among these 5 tribes, and they started to rebuild their government, their religious institutions, their judicial system, their economy, and all was going relatively well until the American Civil War started. The Civil War turned out to be devastating for all 5 of the tribes. They were all in a bit of a conundrum as to exactly sort of how to play this war among non-Native Americans. The United States had forts throughout what was then, again, unofficially called the Indian Territory, designed to protect the nations from, among other people, you people, Texans, who had been lined up for decades now along the Red River, eyeing the lands of these tribes and thinking, gee, if there were only an opportunity. So when the Civil War started and Texas seceded, there was a great deal of anxiety on the part of the tribes that Texans would take this as an opportunity to cross the Red River and invade the Indian Territory. The Confederate government played off this fear and negotiated treaties of alliance with all the tribes, which they themselves agreed to because the US pulled all of its troops back to Kansas. So they felt defenseless. They also had some economic interests. They were, the 5 tribes were slaveholding agricultural tribes, and so this was played off as well. But in any event, the war, of course, ended badly for the tribes, which engaged in their own civil wars, and Confederates lost. The United States came in 1866 and entered into new treaties with these tribes, in which old treaty rights were recognized, but the land base was changed. And the tribes effectively had to cede the western half of Oklahoma, which would then be filled with tribes from other parts of the United States. The Kiowa, the Cheyenne, the Arapaho came down from Colorado area, Northern Plains tribes came in, the Comanches, the Apaches into southwestern Oklahoma, etc. And then, to tell the Oklahoma story, there was a little bit in the middle that they didn't assign to anybody, the unassigned lands. And those lands, finally, the federal government decided, we'll just open up to whoever wants them. And that's the origin of the land runs, which we began in 1889. Where I live in Norman was unassigned territory. It had originally been Seminole land, lost to the Seminoles as a result of the 1866 treaty. So, all right, so that's sort of an overview and how the Muskogee Creek in 1866 ended up with a reservation in the eastern part of the state, smaller than the one they started with out here, but still fairly sizable. And it included a little creek town that would become the city of Tulsa by the end of the 19th century. And in fact, today, that old reservation boundary includes about 2/3, the southern 2/3 of what became the city of Tulsa. So there's a new reservation created. It's a little smaller, Muskogee Creek, and the other tribes get their governments going again. But then in the late 1800s, in 1887, Congress decides, you know, one of the problems we have with sort of economic development in Indian country is that these tribes own their lands collectively, which was fairly universally true. The tribes would have allocations of farms, et cetera. But there wasn't any sense, for the most part, and certainly in these tribes, of private property interests enforceable against the government, et cetera. And so what Congress decided in 1887 was, what we ought to do is go around the country and cut individual deals with tribes to apply some basic variant of the following formula. You guys, and we'll do this tribe by tribe, will conduct a census. So we know who you are and how many you are. Then we'll survey the lands, the collectively held lands of your reservation, and divide them up. And the common formula was into 160-acre ranches and 80-acre farms. So they're squares or rectangles. And we'll put together a big map, and then you all will come in on a given day. We'll set up an office out in your Indian country, and you'll pick. And every individual whose name is on the census, so that's old people, young people, men, women, doesn't matter, gets to pick their own individual parcel, and then that will be effectively deeded to them. And it will be their individual farm or ranch. And it's per capita, it's not per family, so everybody's going to get something. There, in most instances, will be land left over at the end, and either the US will buy that, we call those surplus lands, or the US will act as real estate agent and sell it for you. And then they started picking tribes and saying, all right, we're going to start with you. So the statute was passed in 1887. It's called the General Allotment Act. The individual farms or ranches are called allotments. They're individual allotments held by individual tribal members. And the idea was, not only will we break up collective ownership, but we'll reduce the size of reservations by alienating what were called the surplus lands again. The Muskogee Creek were subject, all 5 of the tribes in Oklahoma were subject to allotment through individual statutes that were each somewhat different. Muskogee Creek's Allotment Act, which is entered into, passed in the early 20th century, says we're not doing surplus lands. You know, you're going to reconfigure the amount of acres that each individual gets, and we're going to allot the entire reservation, not just part of it, so that the reservation itself remains intact. And so that's what was done for Muskogee Creek. Initially, the lands could not be sold. They had to be retained by the individual allottee, but through a process, either passage of time in some places, or federal declarations that individuals are competent to manage their property, these alienation restrictions were removed for many parcels, not all. And so once the alienation restrictions removed for an individual farm or ranch, it could be sold, and in many cases was. And so after allotment, of course, what you see throughout Indian country is a gradual entry into these allotted reservation lands of non-Indians, and a checkerboarding of, you know, who lives. So this might be a non-Indian here and an Indian with restricted lands, right? Can't sell them next door. And then next door to that, the farm might be an Indian who's free to sell lands because the restriction has been removed, et cetera. And this checkerboarding has complicated tribal jurisdictional issues ever since. That's a topic we can get into later if you're interested in talking more about it. But so back to McGirt. So what happened in McGirt, Muskogee Creek Nation went through allotment, and then time passed. In the years after the allotment of the Muskogee Creek Reservation, the state of Oklahoma stepped up when the state was created soon after Muskogee Creek allotment, and then the state created its own court system, police, et cetera. And the state said, well, you know, you're allotted a lot of non-Indians living there, and there had been other statutes passed relating to, for instance, tribal judicial power, et cetera. But Oklahoma said, well, you know, I guess that your reservation doesn't exist anymore, and that means that you're all subject to state jurisdiction. So let's start enforcing it. And Oklahoma did for decades, including, most importantly, from McGirt, state criminal jurisdiction. So people would commit crimes, and the state's position was, if it's not restricted lands, then it's subject to state criminal jurisdiction. And so people would commit crimes on these lands, be arrested, prosecuted by the state, and sent to state prison. And that happened again for decades, until finally a guy a couple of years ago named Murphy, who had been prosecuted. He was a Muskogee Creek tribal member who committed a crime. in that old 1866 reservation, but it wasn't on restricted lands. And so the state arrested him and prosecuted him. It was a murder prosecution. He got sent to state prison, and he raised the question, how is it that the state has jurisdiction over me? Because as far as I can tell, the Muskogee Creek Reservation is still intact. And if the crime occurred on Muskogee Creek Reservation land, and I'm a Muskogee Creek citizen, then all sorts of federal rules governing criminal jurisdiction come into play. And I'll describe those momentarily, but let me get rid of Mr. Murphy. So that case went to the Supreme Court a year ago and was argued. Justice Gorsuch had to recuse himself. It had come through the 10th Circuit, and Murphy had actually won in the 10th Circuit on his argument that Muskogee Creek Nation Reservation still existed, and so the state had no jurisdiction to prosecute him. And so we were all waiting for a decision in the Murphy case. The opinions were, and some of you may know this, but opinions were delivered at the very end of the term. Waiting for Murphy, waiting for Murphy. There's only 8 justices. A lot of us were expecting a 4-4 tie. But at the very end, they announced Murphy scheduled for re-argument next year. And we were kind of surprised. There had already been oral argument and there had been further briefing on particular issues. But so we sat back and waited for the summer to pass, and the new calendar was announced, and Murphy was nowhere on it. And so we waited, and finally Murphy got sent back. And the Supreme Court decided to take another case that raised precisely the same issue, which was the McGirt case. Now, and that was the case eventually that they decided. McGirt had not gone through the 10th Circuit, which meant that Justice Gorsuch didn't have to recuse himself, so they had a full complement of 9 justices. And that seems to have been the reason they wanted Justice Gorsuch's participation in the case, that they punted on Murphy and took McGirt. Now, McGirt is not a Muskogee Creek citizen. He's a Seminole citizen. He had allegedly committed a crime in Muskogee Creek Nation. Tribes, where tribes have criminal jurisdiction, it covers crimes committed not only by their own citizens, but by citizens of other federally recognized tribes. And so McGirt's position, Jim C. McGirt, Mr. McGirt's position was, like Murphy, I should not have been prosecuted by the state. They don't have jurisdiction, the federal government does. And then referring in his argument to the series of federal criminal statutes that I want to talk about now. So here's how criminal justice works and criminal jurisdiction works in Indian country. And it's a little complex, but so I'm going to try and kind of just bottom line it for you. States do have criminal jurisdiction over crimes that occur in Indian country if the crime is committed by a non-Indian against another non-Indian. Those crimes are subject exclusively to state jurisdiction. They happen a fair amount. So imagine it's a tribal casino and a non-Indian starts beating up another non-Indian. The state police will be called, the state will prosecute those cases. The tribe and the federal government don't have anything to do with it. But if a tribal citizen, again, of any tribe, is involved in the crime, either as the perpetrator or as the victim, then the state is out of the picture. And the question will be, which of the 2 remaining sovereigns, the tribe or the federal government, or both, is the appropriate place to prosecute? And the rules there, in short, if it's a, I'm going to use the phrase misdemeanor, but it's really a series of crimes not listed as federal major crimes in the statute I'll talk about in a minute. So if a misdemeanor is committed by an Indian, by a tribal citizen against another Indian tribal citizen, then the tribe has exclusive jurisdiction to prosecute. If a crime, and again, I'll use the word somewhat inartfully, but misdemeanor is committed by an Indian against a non-Indian or vice versa, then the federal government has jurisdiction. And if the perpetrator is an Indian, then the tribe will have concurrent jurisdiction. But if a major crime is committed, and that includes a list of enumerated offenses, including murder, including child sex abuse, which is what Mr. McGirt had been accused of. Murder was Mr. Murphy. Then basically the tribe backs out, even if it's a tribal member defendant. They have jurisdiction, but they have sentencing caps, so they usually don't exercise it. And the federal government steps in under a statute called the Major Crimes Act, which, if you're interested, is found in Title 18 US Code. The two federal criminal statutes are sections 1151, or rather 1152 and 1153. And so what Mr. McGirt's argument was, look, so I'm a tribal citizen, a citizen of a federally recognized crime. I committed a crime inside the Muskogee Creek Reservation, and that qualifies as Indian country for jurisdictional purposes, and I'll say a word about that in a minute too. And so I should be prosecuted exclusively by the federal government, and the state had no jurisdiction. And he was right, if in fact that reservation was still intact. And this is the last thing I'll say before I look at the, I want to say something about the opinion, is the question became, well, is the reservation still intact? Because if it is, then it's Indian country. Indian country is the term of art we use. Indian country is defined again in the US Criminal Code in 18 U.S.C. 1151 to include three types of land: former allotments, dependent Indian communities, and then most importantly, 1151A, which is all lands within the bounds of a reservation. And so that was Mr. McGirt's argument. The reservation's still intact. The alleged crime took place within the bounds of a reservation. That's Indian country under 18 U.S.C. 1151. And so the federal government has jurisdiction here and the state government does not. The 10th Circuit in Murphy had looked at the history of Muskogee Creek allotment and decided that Murphy was right. The reservation was intact, but the Supreme Court hadn't yet ruled on it. Historically, the test had been, and this is from a case called Solemn versus Bartlett, that Congress has the power to, and here's the term we use, disestablish Indian reservations. So it isn't a reservation anymore. But in order to find that that's what Congress has done, we have to find clear intent in the allotment statute that that's what Congress intended to do, that it wasn't simply dividing up a reservation, so changing land ownership within a reservation that's going to continue to exist, but they wanted to kind of blow up the reservation. So it's not even Indian country as a reservation anymore. And if you can't tell, or in order to inform your understanding of Congress's intent, the court had said in the Solemn case, you're allowed to look at surrounding circumstances. What's the legislative history of the Allotment Act? How did people behave on the ground? You know, what did the tribe understand? And if that still leaves you not entirely sure what Congress's intent was, you can look at subsequent demography, theoretically right up to the present time. Are there a whole lot of non-Indians living there now? Because if so, you know, it'd be kind of a mess having the tribe take jurisdiction. So maybe we ought to find that Congress's original intent was to disestablish the reservation. And that had been the test right up until the McGirt case. And really the historic element in McGirt, it's partly the impact on the ground, but it's partly the change in the way that the Supreme Court, this new sort of Indian law Supreme Court majority, which is the four traditionally thought of as liberal justices plus Justice Gorsuch, view the whole disestablishment process. And it's really simple. What Justice Gorsuch says as a textualist is, yes, as in Solemn, you look at the statute first, but what you're looking for is, as was suggested in Solemn, clear evidence that Congress intended that this reservation would cease to exist, that it would be disestablished. If you don't find that clear evidence, then you're done. You don't look at surrounding circumstances, you don't look at subsequent demography, none of that's relevant. So this is pure textualism, which is Justice Gorsuch's bent, but candidly combined with a jurist who has extensive experience adjudicating Indian law cases as a judge on the 10th Circuit. He probably brings more experience to this area of law than any justice we've ever had. And I think it's not too far afield to think that he may become the new lead voice on Indian law cases, and that textualism, which actually has certain advantages for tribes by sort of returning to the fairness and substance of the original 19th century, usually 19th century deal, and forgetting all the bad stuff that's happened to tribes since. That sort of rule may actually end up working a net benefit for tribes, for justice, et cetera. And so that's one of the things that we're looking to see from this. Another thing I'll say about the larger implications of the decision, and then I'll talk a bit about Oklahoma, and then I want to stop talking and let you all ask questions. The fact that there were no concurring opinions, I find to be potentially significant. I've been told that that's the MO for the liberal side now. They all agree with each other, but it's rare in Indian law. Usually in Indian law cases, we get a number of concurring opinions in the majority, which creates a certain amount of uncertainty. But this is everybody buying into Justice Gorsuch's understanding of these issues and approach to resolving the case. And so I think that sends possibly a bit of a signal. Because there are other tribes whose lands were allotted, of course, we've started seeing some movement in not only in Oklahoma, but in other parts of the country where people are pulling out their old allotment agreements to see, assuming that they've found, have had their reservations found to be disestablished or diminished, which is to say parts of it found no longer to be attached to it, whether there's maybe a case to be made that those decisions ought to be revisited now. And then within Oklahoma, the 5 tribes are all have allotment agreements that are similar to the other of the 5 tribes, similar to the Muskogee Creek Allotment Act. And so there's a fairly wide assumption that McGirt applies to them too, in some sense. And then this has triggered negotiations even before McGirt came down on settling jurisdictional issues. And it's also triggered, we've had lawsuits popping up, habeas petitions and appeals and pending criminal prosecutions, or rather arguments being made in pending criminal prosecutions that, hey, I'm an Indian and my crime was committed allegedly in Indian country too. And so McGirt applies and the state doesn't have jurisdiction, this sort of thing. And so what we're all in Oklahoma doing now is kind of figuring out what the new jurisdictional landscape will look like. On the criminal side, most immediately, but because there are implications relating to civil jurisdiction, civil adjudicatory and regulatory jurisdiction, from finding that a particular piece of land is Indian country, then we're kind of starting to look at those too. There was an initial agreement between the 5 tribes and the state attorney general on jurisdiction that basically created a concurrent jurisdiction framework. The intent was to submit it to Congress. Congress could pass it as a statute, and that would have sort of addressed the issues. But 2 of the tribes pulled out, basically, including the Muskogee Creeks, the day after this tentative agreement in principle was announced. And so now the governor's created a commission to come up with a proposal, and the tribes are sort of working on this among themselves. And Congress, I think, is largely waiting for something to come from the tribes in the state that they can enact as legislation, assuming it's found that congressional action is needed. All right, that's longer than I intended to talk because, as I said, I want to leave as much time as possible for you guys. So that's sort of an overview of McGirt. Big impact, potentially, around the country, certainly perceived locally by the tribal nations as somewhat shocking, frankly, recognition of sort of the validity of old claims and beliefs, and a recognition that justice can be done damn the consequences. So there's jurisdictional complexity, but we need to do what's right, which is very much the tone of the opinion. All right, I'm going to stop talking now. I can turn it back over to you, and I'm happy to take any questions.
We've got a few, but obviously what you're talking about is not something we get to hear about all the time, and thank you for that. We do have one question that just popped up, so the timing is pretty fortuitous. And the question is, how can, if you have a treaty, how can Congress disestablish reservations when they have theoretically a contract? What's the theory or practice behind that?
Yeah, it's a great question. So this is a question that came up in an early 20th century case called Lone Wolf versus Hitchcock. We had a treaty the U.S. did with the Apache and Comanche and Kiowa tribes, and it was clearly breached. Lone Wolf for the Kiowa and others went to Washington to protest, and the Supreme Court looked at it and decided in the Lone Wolf versus Hitchcock case, it's true this treaty was breached, but because Congress is the guardian for the Indian tribes, and that's a principle that came out of a couple earlier cases, and has certain obligations to the tribes, Congress has to have the power to abrogate treaties that it has made with those tribes, presumably if it believes that abrogation is in the tribe's best interest. So they created something called the plenary power doctrine. And the one thing we know about plenary power is it includes the power to abrogate treaty obligations to tribes. Now, it's possible there are takings consequences. That's a bit of an unanswered issue. And Congress is supposed to act in good faith when it exercises this. So there are potential good faith claims that could be brought. But that's been the law ever since, that Congress is empowered to breach its obligations under Indian treaties.
That's kind of like the judge character in Caddyshack. I sentenced boys younger than you to the gas chamber, but I did it for own good.
Yeah,
more or less. We can go ahead and abrogate because it's for your own good that we take away these treaty rights.
There it is.
I'm guessing, would there be a constitutional challenge on that? Because Indian Native American citizens are still citizens, but what is? I guess they did it, but what's the thought on that?
Yeah, so you raised another really interesting question. So Native American citizens are citizens of the United States. Many probably don't know that that's only been true since 1924. And state citizenship in some states wasn't granted to Native people until the 1960s. And so this is a relatively modern phenomenon. And as citizens, individual Indians certainly have constitutional claims that they can make when they're discriminated against, right? Equal protection claims. The tribal collective, however, as a government, and that's what's impacted by these treaty breach cases, is not recognized under the Constitution. And in fact, tribes are considered extra constitutional sovereigns within or without, I guess, the American system, but sharing land in the territory of the United States. And a lot of people don't realize that either, that there are really three. We learn about two sets of sovereigns in grade school, the states and the federal government and federalism and stuff. We don't learn that there are tribes too, 570 some of them, who are sovereigns exercising inherent power within the same space. So they're extra constitutional. Tribal governments aren't directly subject to the Bill of Rights, for instance, of the US Constitution. They operate outside of our framework. And so when the federal government does something to tribes, it's really treated as a foreign policy matter and less as an equal protection matter.
Interesting. So we do have a question, that's a big chunk of fracking / oil producing property. What are the implications on the civil side of McGirt? Yeah,
that's a great question. So, and people in the oil and gas industry are asking that here now too. And the answer is, we still don't know entirely, but the expectation is there will be should be very little impact. The reason is that on the civil side, tribal jurisdiction over non-Indians on fee lands, right? So if it's restricted land that the tribe owns, that's different, but they're the landowner, et cetera. But if you're drilling on, just somebody's private property within this area that's newly been recognized as Muskogee Creek Reservation, then the tribe's jurisdiction over you is fairly limited. The default is that they have no civil regulatory jurisdiction over you. unless one of two circumstances applies. Either you're in a contractual relationship with them and you basically agreed to their jurisdiction, and existing gas and oil leases, they already know whether that's true, or you're engaged in some sort of conduct that would threaten, basically threaten the tribe's self-government. The language is threaten or have a direct effect on the tribe's political integrity, economic security, or health or welfare. And the Supreme Court has never found that exception to give tribes jurisdiction over non-Indians.
Well, wouldn't Standing Rock kind of fall in that category theoretically, something like that?
Well, the Dakota Access was actually outside the tribe's reservation.
No, I get it, but I'm just saying, if they're going to
but if you were in it, yeah, so maybe you'd make that argument. Yeah, if you had something like that, then you could make that argument. But arguments like that have never been successful. So at least before the Supreme Court. And I suspect because it's a self-governance thing, again, you raise a question that people are talking about, but my guess is, just based on the case law that we have to date, that it would need to be something far more extreme than that before the tribe.
Poisoning your reservation's drinking water?
Sorry?
You mean besides poisoning the tribe's drinking water, the
besides
Ogalas?
Poisoning the tribe, yeah. You can make the argument, and it's possible, but we haven't seen a willingness from the Supreme Court to go very far. In fact, as I said, we don't have a lot of cases, but in none of them has the tribe
Would that get adjudicated in a tribal court first instance or a federal court, or how would that work with McGirt?
Well, so if it were a civil claim like that, you'd probably bring it in, depending on who was bringing it, but you could bring that in state court, and the argument would be that this is something for the state to adjudicate. If the tribe claimed jurisdiction over it, there is an exhaustion rule that would say, that you should exhaust the tribal court remedy first, and then you can bring a federal action charging the tribe's exercise of jurisdiction. So it's possible we'd see a sequence of those. My guess, though, candidly, is that I mentioned this statement in principle. The agreement in principle? Oklahoma has a really solid history of tribal state compacting. I've been involved in it. I worked as special counsel in Indian Affairs as sort of a moonlight job for Governor Keating and for Governor Henry. And we did a lot of compacting with tribes because nobody benefits from uncertainty on the civil regulatory jurisdiction side. Tribes don't, nobody benefits from confusion. And so, what will happen, and what is happening, is everybody's sitting down now and trying to figure out what the best way to do this is, right? Who should exercise jurisdiction over this, and who should exercise jurisdiction over that? And with input from tribes, from oil and gas, et cetera, my understanding from people I talk to in Congress is they're waiting for that sort of resolution, a negotiated resolution, and then to the extent necessary, they'll pass it as a federal statute. And that'll settle all of the uncertainty in the jurisdiction.
Right, but I mean, obviously you're talking about Oklahoma, but if you talk, for example, about the Oglala Sioux, if it's over tribal lands, is that, for example, something that would have an application out of McGirt? In other words, you have a right now as a tribe to assert your own jurisdiction regardless.
Yeah, no, so McGirt really only impacts what lands are reservation lands, and that's not an issue for Oglala. They weren't allotted, so they've still got a large communally held land base. They know where their reservation is, and so they've been acting under that rule forever, right? And so that's where you might see, if there were some sort of a perceived threat from, a pipeline or something, they can already do that. And they could have done that 15 or 20 years ago if the pipeline's running through their reservation.
We have a very broad question, and this is back to the criminal courts or criminal. What are the pros and cons of being in state, tribal, or the federal court system from the viewpoint of the accused, just generally?
Yeah, great question. And we're hearing a lot of talk about this too from people who are currently incarcerated by the state and trying to decide whether they want to subject themselves to a federal prosecution. And I think the big anxiety is federal sentences tend to be stiffer. A lot of people seem to be making the call based on how close they are to finishing out their state sentence, right? If they're pretty close, then, I know this place and I got friends, and, why would I want to subject myself to a federal trial? But if you were prosecuted and you think you were innocent, and it was an unfair state prosecution, then you might want to try and take another chance too. tribes have sentencing caps. Muskogee Creek is what's called a tribal law and order tribe. So they can only sentence people up to 3 years per enumerated offense. So most people, you know, misdemeanors, people who commit misdemeanors are probably going to be thinking about, you know, tribal prosecutions more than anybody else. But if you've committed a felony, then you're really looking at state or federal.
Well, I'm not sure I follow you. Why wouldn't have the tribes basically said we're not going to prosecute within our courts felonies?
No, it's another one of those instances. Congress, acting as a good faith guardian, in 1968 imposed a sentencing cap on tribal courts exercising criminal jurisdiction. It's actually 1 year per offense for most tribes. And then in 2010, they let select tribes expand that to 3 years per offense.
But for any offense at all?
For any offense at all.
So why wouldn't you want to be in a tribal court if you kill someone?
Well, you could be, and the tribe could sentence you to a year, but the feds probably aren't going to let that go. And there is no double jeopardy bar against subsequent federal tribal prosecutions.
So what you're saying is the tribal court will exercise jurisdiction, they might sentence you a year, but the federal courts would still have jurisdiction to come in and
sentence you to whatever they wanted to. Yeah.
Gotcha. Well, obviously you understand how it works in the U.S. courts on the defendant side and the prosecutorial control. One of the things you raised, which really caught my attention because I happen to have read something about it recently, is the role of the tribes in the Confederacy. Because I know there were Cherokee regiments, there were a large number, not a large number, there were a number of Cherokee slave owners, and I actually read something recently talking about on the Trail of Tears. You know, if you think it was bad to be a Native American, how bad was it to be a slave of the Native Americans? Is that something that's got a lot of attention or really focus? I know that there's some issues more recently about that, but has that really impacted in Oklahoma at all, given that past?
Yeah, so there are a couple ways to go there. One is sort of the Confederate monument stuff, and there are people, and I gather that may be part of your question, Black Lives Matter and stuff. So yes, that's been a bit of an issue, less than in other places because there isn't a whole lot of attachment to sort of historical memories of the Civil War here. They were dreadful. There were internal civil wars, as I mentioned. So Cherokees, for instance, had a Confederate monument in front of their courthouse that had been erected when the courthouse belonged to the county. And then it was reacquired by Cherokee Nation. They had no trouble saying, you know, we're gonna move that to the tribal museum or wherever it's ended up or something. So that hasn't really been a big issue. The Civil War remnant issue that's been alive in the tribes is the citizenship status of descendants of enslaved people who were called the freedmen. And I think 3 of the tribes had treaties that required them to grant citizenship, tribal citizenship to their freedmen. And so the Seminoles, including Muskogee Creek and the Cherokees, they're ongoing, I guess in Seminoles too. There's an ongoing campaign to restore full citizenship rights to freedmen, or any citizenship rights to freedmen, because a number of the tribes have disenrolled them.
So one of the other, and I found it interesting because I started back doing maritime law, and the Supreme Court justice who wrote most of the decisions while she was on the court was actually Sandra Day O'Connor. So it was always an irony that we had a judge from Arizona writing most of the maritime cases for about 14 years. In terms of kind of the law going forward with this role that you've talked about with Justice Gorsuch, how do you see that? I mean, is there going to be a lot more? Because it seemed like they would jump on these cases because it was a textual case on the admiralty side. Do you see this court getting more into Indian law?
Yeah, I sort of do. And sort of partly because I think people are encouraged now on the tribal side to actually start filing cases again. You know, for a long time, lawyers just sat on them because there was no good to be realized from getting a case before the Supreme Court for a long time. I should mention Justice Sotomayor as well, and Justice Breyer, both of whom have expressed strong interest in Native American cases. And I think I went to the Murphy argument. Justice Kagan is really all over these issues. She's real smart on Indian law. So it may be that this perception of a renewed interest on the part of a majority of the court will trigger a real explosion of Indian law litigation.
Which means where? Where will that where do you anticipate that might show up?
Sort of depends. Reservation cases could come from almost anywhere after McGirt. People are looking at their allotment acts now. but primarily Indian law cases tend to come either, we had a run of upstate New York cases, usually, most of them land cases, but other jurisdictional cases, and then from sort of Oklahoma towards the southwest. And then we had a long run of sort of fishing rights cases, another treaty case from the Pacific Northwest. So those are the areas, although you mentioned Oglala and probably some of the Lakota reservations, we may start seeing environmental claims.
Well, and we had a chance to visit last week, your background, this kind of caught my attention, you know, how you got into this particular area, but really, would there be this much litigation, this much review of what's going on in Native American without casinos? Because that's something that seems to have really impacted the area of law as well. Tell us about that.
Yeah, so there's not a whole lot of litigation involving casinos, but you're absolutely right. Casinos became suddenly a way to make money for tribes. Tribes, when people think about tribal economic development, most folks don't realize they're part of what inhibits it is because restricted lands can't be mortgaged, so you can't borrow against your real estate, so it's hard to accumulate capital to engage in any sort of economic development. And the other thing is you can't move. So, you know, where you are, that's where you are. It's not like you can find another corner for your Italian restaurant, right? You are where you are. And if you happen to be in a remote location, getting people to come visit you is a real challenge. Casinos change that because people will travel to go to casinos. And we love all you Texans coming up to WinStar and, you know, out to Durant, to the Choctaw.
You're welcome.
Yeah, we really appreciate it. And so that it was the infusion of that money that suddenly made, frankly, tribes attractive targets for state tax commissions. You know, in a sense, I don't mean to sound like mercenary, but there was suddenly revenue there that was available theoretically to states. And so we've seen a lot of states sort of move to take a share of casino revenues, but also just more activities that tribes were involved in that would give rise to potentially more litigation.
We do have a question as far as what are the far-reaching implications for as far as non-Native Americans committing crimes that are considered crimes by the reservation, but not by the state. So, for example, you know, concealed carry, something like that.
Yeah. So the Supreme Court, in a decision from the mid-'70s called Oliphants, decided that tribes cannot exercise criminal jurisdiction over non-Indians. Full stop. And it doesn't matter where the crime is committed, under whose law the conduct is considered criminal. And there's only one exception to that now by federal statute, and that's in limited circumstances, non-Indians who commit acts of domestic violence against Native women in Indian country can be subject to tribal prosecution, but that's it.
Are there any, and we have about time for about 3.5 more questions. Are there any implications for property rights? In other words, what is the state of law on takings and suits for compensation? Do you see McGirt or this potential explosive growth in Native American law impacting that?
Yeah, no, because the question of the continued existence of a reservation, so the sort of expanded Muskogee Creek Indian country, only affects jurisdiction. It has no impact on vested property rights. So all of that will stay exactly the same. And the Muskogee Creek would be, frankly, powerless to change it for virtually everybody because of the limitations on their exercise of civil regulatory jurisdiction. And I don't know they'd be incentivized to, in any event, even if they had the power to.
So hot ticket or hot button issue, what about pro-choice abortions? Can Oklahoma restrict or regulate them on tribal reservations at this point?
Well, that's actually a really interesting question. So tribes, again, I guess, and I haven't ever really thought about it, but tribes have no criminal jurisdiction over non-Indians. So we have to take that whole segment of the population out. And then the question would be, well, what about Indians, so citizens of federally recognized tribes, performing or receiving abortions on tribal restricted lands, for instance, from a tribal provider? And I can't think of an instance where that's happened, but it's a great question. And off the top of my head, I can't think of a reason why it couldn't happen. Now, having said that, I don't know of any tribe that actually, I honestly don't know. I give plaudits to the person who asked the question.
Our former Harris County Democratic chair, so he stumped the professor. We ought to call that the new last 4 minutes. But
yeah, well, yeah. No, but I will give it some thought. I think it may be that it's not a live issue because there are no tribes that allow abortions in Oklahoma. So I'm not sure that it may be more hypothetical than anything else.
You're saying the tribes have prohibitions themselves? That
Yeah, the tribes, we're Oklahoma. So, there's a lot of conservative governance in tribes too on some social issues. And so, so I would be surprised if there were a tribe that had publicly legalized abortions and where the conflict had actually arisen.
Well, you caught my attention when you referred to law and order tribes. What does that mean?
Yeah, so Congress in 2010 passed a statute called the Tribal Law and Order Act that included a number of provisions. The most important was it allowed tribes that wanted to ratchet up their sentencing authority from 1 year to 3 year per enumerated offense. And then there are all sorts of defendant protections that come along with that. But that's what I meant. That's what I was referring to.
Last question, then I'm going to turn it over to you for some closing thoughts, and thank you again. Are there any, as I understand it, and you're the expert in this, there's one federally recognized tribe in Texas, is that correct?
Yeah, I honestly don't, I've been told there aren't any. There are a number of state recognized tribes, but it could be, so that's something else for me to look at.
There is a Coshada casino about an hour and a half north of Texas, but
yeah.
Go ahead. I'm sorry.
Unless that's a casino established under state law, it would have to be a federally recognized tribe. So it may. I should know the answer to that question. I'm embarrassed I don't.
Well, this is not Trivial Pursuit. You're doing great, and thank you. And it's kind of, and I know there's 3 tribes. There's a tribe over in Eagle Pass. There's an El Paso, and then I know the Coshada. Is there any what you would anticipate potential Native American law hot button issues, things you might expect our practitioners to see because of McGirt, or just because there's more attention?
Yeah, so yeah, and maybe in Texas, as we're talking about, but I'm betting that a lot of your members and maybe a lot of people who are participating today will have clients in Oklahoma. So oil and gas industry clients or any other clients. I'm guessing maybe more oil and gas industry clients, but maybe some others. Will those clients will be raising questions about exactly what to do and what this means and stuff like that. And so what I wanted to offer is if and I may have mentioned this earlier too, but if any of you have any questions that you want to pose to me offline, I'm more than happy to visit with you and maybe refer you to folks locally who might be experts in both fields that you might be interested in working with as local counsel to help your clients navigate the new landscape.
Well, thank you, Professor. We're about to close. Any kind of closing thoughts? I know you mentioned something about having a network of former students across the country, but what else, that you kind of leave us with at this point, with this all kinds of different things going on that you'd like to share with us at this point? Yeah, so one is come north once it's safe and spend money at tribal casinos. And the other is to just thank everybody. I'm impressed with I was impressed with the invitation, with the level of interest and the turnout today. I think it's fantastic that you all are paying attention to this issue and interested enough to invite me and let me talk ramble on for as long as I have. I should mention too, I guess last thing, since you give me the floor for one more minute, those of you who are really interested in this or know people who want to develop an expertise, we do have an online LLM program in Indian law, start to finish our entire Indian law curriculum that you can complete in 15 months. It has exploded recently, unsurprisingly because of McGirt. We also have a master's degree program for non-lawyers. If you have a paralegal you'd like to make expert in Indian law, they can get that master's degree in 15 months. And it's also our curriculum sort of geared towards non-lawyers. Or if you know people in oil and gas, we have an oil and gas program too for an LLM, for that matter. But you guys do that sort of thing in Texas as well. Yeah, we do. There you go. So, but if anybody is interested, that's a question that you could send to me too, and I'd be happy to put you in touch with the right people. Thank you again, professors. I'll close with just a reminder, and Jerry caught me. I called him James Dean. It's John Dean. I don't know what I was thinking. There was some kind of slip there. I'm not sure why. He'll be with us on September 3rd. Monday, as I mentioned before, August 17th, we're co-hosting with Art Pronin an opportunity to have a dialogue. And by the way, you're welcome to come back for that. If you want to stump James Carville on some political questions, Professor, you're going to have that opportunity on Monday. And then obviously, if you haven't registered, you know, or this is your first time at one of our webinars, we're going to continue to offer this free. We certainly welcome you joining our organization. It's only $75 a year. As soon as we're back up and running live, that'll get you one free lunch. But we'll continue to do the hard work, and Steve Dubel and Barbara Radnowski of having great speakers like Professor Radnowski. Thanks for joining us. I hope to see you soon Monday in our webinars going throughout. Thank you again, Professor.
Thank you.